For over 40 years, attorney Chip Nix has experience in personal injury claims involving the most serious and catastrophic injuries. Helping victims injured at work, at home, or on the road is attorney Chip Nix's mission. The law offices of attorney Chip Nix is committed to representing clients with integrity and getting the compensation they deserve. This evening, attorney Chip Nix discusses the legal issues that affect you most. This is Justice for You with your host, attorney Chip Nix.
Welcome to Justice for You, where we talk about what you need to know if you've been injured or if you are being denied justice. Often, people find themselves injured in a public place due to slipping or falling. Tonight, we will talk about premises liability cases. With me tonight is my fellow attorney, Monica Giroux, to talk about premises liability. Monica, thank you for joining me tonight.
Pleasure to be here. Thank you for having me.
You bet. Do you mind telling the ladies and gentlemen a little bit about your background?
Not at all. I started working in law offices in 1989 as a court runner. And while I was in college, I worked at a plaintiff's firm up in Huntsville, Alabama as their receptionist, secretary. I managed the court runners. I did a lot of stuff up there. And then I moved to Montgomery to go to law school at Jones School of Law. That's when I met you. I took a job as a paralegal at an insurance defense firm. Worked there full-time until 2001. Worked there as of counsel part-time until 2009. And from 2009 until 2016, I had my own small practice representing people who needed help. And then in 2016, I joined you at the law offices of Chip Nix.
And I am glad to say that we are now practicing law together.
That we are.
It's good to have you again. I mean, we worked together previously, and it was a great thing for me to be able to get you back.
Thank you. That means a lot.
Tonight, ladies and gentlemen, we're going to talk about premises liability cases. Premises liability cases are situations where a person is injured while they're on somebody else's property. So tonight we'll be talking about that. Monica, there are three factors, as I understand it, in a premises liability case that are important to determine up front.
Yes.
What are those?
Okay. The first thing you have to look at in a premise liability situation is what is the status of the person who was injured. The second thing you have to look at is what caused the person's injury. Was it something, usually it's going to be something specific on the property that causes the injury. Then you have to look at where the injury happens. And in that, you look at who's responsible for maintaining that part of the property. Because if the person's injured, you have to figure out who was responsible for making sure that the defect wasn't there or that the condition was safe for people to be on the property.
I got you. And the first thing I think you're going to tell the folks tonight is what is not a good premises liability case, right?
Yes.
And you're going to give three examples from your own experience.
Yes. Sometimes the best way to explain what something is by explaining what it's not. So, first example. I'm kind of short, okay? Just a little bit. So I wear high heels sometimes, and I have to be careful about how high I get with the high heels, but I had found this perfect set of shoes. Women know what I'm talking about. And I'm going into the church building to deliver some things for a project at church. I'm walking back out. I'm walking down the sidewalk. There's nothing wrong with the sidewalk. There's nothing wrong with the landscaping. And the next thing I know, I am down on the concrete. And it was nothing more than that 5.5-inch heel was beyond my skill set.
I got you. So contributory negligence is a defense to that? Assumption of the risk is a defense?
I think that one goes more to assumption of the risk.
Okay.
I mean, I should have looked at those shoes and went, that's just a disaster waiting to happen, but I didn't.
Give us another example
Okay.
of what's not.
Another good example. Do you remember when Hurricane Ivan came through?
I do.
Okay. My husband works in information technology. So as soon as the power was on at his building, He went out to the building to get the system up and running and make sure that, you know, everything was working the way it needed to be. We didn't have power at the house yet, so I went and found a fast food restaurant that was open, picked up breakfast, went out to his building to drop off some breakfast for him and I think maybe 2 of the people he was working with. And it was still rainy and drizzly outside. I had on tennis shoes that day. His office has this beautiful smooth tile marble type floor in the foyer. They had the yellow cone out that says caution wet floor. Walked into the lobby of the building and slipped and fell right on my rear end in the lobby.
Well, why was that one not a good premises liability case?
2 things really there. The first thing is a lot of long-standing Alabama law that says rainwater or when it's raining outside gives you what is called prima facie notice that a floor or any surface could be wet and that you need to be careful.
I see.
The second thing that makes it not a premises liability case is that there was a warning sign out. They had actually put out, even with the case law that says, you know, it's going to be wet, be careful. There was a warning sign out that said, hey, caution, wet floor.
Right.
So they had given me notice of a potentially dangerous condition, therefore it was not their fault that I slipped and fell.
I got you. Okay. We're going to go to a break right now. Thank you for watching Justice for You. When we come back, we'll talk about examples of what is a good premises liability case. Hello, my name is Chip Nix. I'm here at the law offices of Chip Nix in Montgomery, Alabama. I want to tell you about a 20-year-old young man that we were able to help a few years ago. He lost his right hand in an industrial accident. We were able to provide a settlement for him that obtained 2 primary parts. The first thing we were able to do through the help of an artificial hand expert was to get him a bionic hand that really functions. And second, we were able to work with a financial company to provide, in addition to cash, $5,000 that will be paid to him on a monthly basis for the rest of his life. If you have a personal injury case, or if someone in your family has tragically been killed, call us. We will search for justice for you. Some people say personal injury law is all about the money. Well, they're right. It's about the money to provide a bionic hand to a young man who has lost one of his in an accident. It's about the money for a family who has lost a mother due to a drunk driver. Yes, for the law offices of Chip Nix, it is about the money. It's about the money to help people salvage a decent life from the wreckage of someone else's carelessness. Justice for you begins here.
For over 40 years, attorney Chip Nix has experience in personal injury claims involving the most serious and catastrophic injuries. Helping victims injured at work, at home, or on the road is attorney Chip Nix's mission. The law offices of attorney Chip Nix is committed to representing clients with integrity and getting the compensation they deserve. This evening, attorney Chip Nix discusses the legal issues that affect you most. This is Justice for You with your host, attorney Chip Nix.
Welcome back to Justice for You. Our topic this evening is premises liability, or in other words, injuries sustained when you fall due to a negligent environment or you are otherwise injured because of an environment. Monica, we were talking about a few things before the first break. One of the things we were talking about was the classification of the person injured and why that's important. Tell you what, tell the ladies and gentlemen what those 3 things are that you mentioned in the first segment.
Okay.
The 3 parts of a premises liability case that are really important. 3
parts. The classification of the person who's injured.
Okay.
The where it happens on the property or what defect or condition causes the injury. And then we want to look at whether or not they've had notice of the potential dangerous condition.
Okay, so let's talk about the classification of the person. What are the different classifications that the law prescribes with respect to the injured party?
Sure. A person can be in one of three categories. They can be an invitee, they can be a licensee, or they can be a trespasser. The highest duty is owed to the invitee. The invitee is there for the benefit of the property owner. So I think a good example there is a retailer. When you go into a store, you are there to shop, you are there to spend money.
All right, so tell the ladies and gentlemen a little bit about why it is important that we understand or determine the classification of the injured party.
Okay, because the classification of the injured party depends, that dictates, if you will, what duty is owed to that person. For example, for the invitee, the property owner has to maintain the property in a safe condition. And if there is a condition that they know is not safe or that cannot be made safe, they have a duty to warn the person of any dangerous conditions.
Okay, so what is the duty to a licensee?
Okay, a licensee is our second category.
Right.
And to the licensee, the property owner owes the duty to not willfully or wantonly injure the licensee.
All right.
And if they know of a hazard or defect that is existing, they have to warn them of that hazard or defect.
Okay, so there's a big difference between the legal responsibility of a property owner in a situation where the person is a licensee from the situation where the person is an invitee.
Yes.
Right? If you're an invitee, it's easier to prove your case against the property owner, right?
Absolutely it is.
Okay, because wantonness, negligence is what you have to prove against a property owner, basically, in an invitee situation. You also have to prove that they knew that there was a hazard. But if they knew that there was a hazard and they negligently failed to do something about that hazard, then you can prove liability against them, and that means that you can recover damages. If you cannot prove that the property owner was unreasonable in the way they approached things, then you can't recover in an invitee situation. But in a licensee situation, you would have to prove wantonness, and wantonness is a lot more difficult to prove. It is virtually the willful refusal to do something for the safety of someone else. So the classifications are important. Is there another classification besides invitee and licensee?
There is. The third category of people who could be on someone else's property is what we call a trespasser.
Right.
And trespassers can fall into two categories. You can have discovered trespassers, and to a discovered trespasser, you basically owe the same duty that you do to a licensee. If they're an undiscovered trespasser, then the only duty that you owe to them is to warn them of any artificially created hazard that might be on the property. Do you remember the spring gun case out of Missouri that you study in law school?
Yeah.
Where the property owner had set up a spring gun to protect an unoccupied dwelling?
Tell the ladies and gentlemen what a spring gun is.
Okay, a spring gun is a gun that in this particular case, it's from 1954, they had a gun set up on the property so that when someone opened the door, it was basically like a booby trap. When someone opened the door, the gun was going to fire.
All right.
And they had the gun set so that it wouldn't kill the person. They had it aimed at the person's lower leg.
All right.
But in that particular case, even though the person who was coming onto the property was coming into that house to rob the property,
Right.
it was an artificial hazard that they had created
Right.
And so the property owner was found liable
Yeah.
for causing the man's injuries.
Even where there was a trespasser.
Right. So this is why when people have electric fences, or maybe they know that they have a vicious animal or something on their property, they put up a sign to warn about it.
All right. Let's talk about a case. Let's talk about a specific situation. The one I'm thinking about, Monica, is a case that I had a few years ago where a lady walked into the repair bay, or actually it was just the entrance to the repair bay in a car dealership. This was an area where vehicles pulled into that place. They would pull in, and then they would be taken to the service area, or they would be taken another route through the building to another lot where they would be parked. But buildings would come in and out of there all day. This area was not roped off or denied access to people who just wanted to walk on it. It was raining one day. She walked into the area, and there was all kinds of residue. There was oil residue, all kinds of fluid residue, smoke residue, all kinds of things had gone onto that floor. And when the floor got wet, it was really slippery. And she fell and fractured her wrist very badly. She had to have 2 different operations on that wrist. Take that case, if you would, and explain to us your thoughts about what kind of a classification she was, and what the liability considerations would be.
You can argue the classifications 2 ways there. We would, of course, argue that she was an invitee.
Right.
She's there for their benefit. They're going to make money
That's
when
right.
they fix her car.
She was going in to pick up a part that she had purchased.
Okay. Yeah. So she's an invitee. So they owe her a duty to protect her, clean up, to protect her from those hazardous conditions.
Right.
And where they know that there could be a hazardous condition, they have a duty to warn her about it.
All right.
So in that environment, you probably can't always keep the floor perfectly clean.
Right.
But you could most certainly have a sign up that warns people that the surface could be slippery and to watch their step. Most of the places I've been to, you pull in and someone else takes your car into that area instead of you going into that area where you could potentially slip and fall.
Right. That would seem like the better procedure. In this particular case, there was one thing in particular that made the case very good for the plaintiff, for us, and that was that we were able to find where they had had another lady walk in to the place under very similar circumstances. It had been raining, and she fell and was injured in almost the exact same area where my other lady fell. So we were able to prove that they had knowledge that it was potentially dangerous in there. So that was very helpful. And
knowledge goes to notice. If
that's
happened,
right.
If it's happened before, reasonably it could happen again.
Absolutely right. What we did in that case, we had a lot of fun in that case, really. I mean, we love what we do. And so we actually, whereas most folks will only take 1 deposition of a defendant, we took 3 depositions of 3 different people who had knowledge about the conditions in that dealership. They all worked at the dealership. We asked them similar questions throughout those 3 depositions, and we were able to get them to contradict themselves. One would say that he knew it was slippery, or that they frequently had situations where they had to clean up during the day. And another one would say, the owner particularly would say, no, we never have anything like that occur. And so they, in a lot of different specific respects, they contradicted each other, which made the case a lot more, a lot better for the purpose of presenting it to the jury and getting them to make a determination. The other thing that was interesting about that case was that it was a rainwater case, and we've talked about rainwater. Okay, so in this situation, rainwater typically is not a good premises liability case because people have notice of it, people have knowledge of it, and they know or should know that the inside of the building could be wet. And so rainwater slip and fall cases are very difficult to win. But in this case, it was rainwater combined with the condition of the floor. The condition of the floor was very bad. And so it was a good case for that reason too. Monica, I think we have to take a break now.
Okay.
Time goes by way too quickly. You're watching Justice for You. We will be right back after this break. Thank you. Hello, my name is Chip Nix. I'm here at the law offices of Chip Nix in Montgomery, Alabama. I want to tell you about a 20-year-old young man that we were able to help a few years ago. He lost his right hand in an industrial accident. We were able to provide a settlement for him that obtained two primary parts. The first thing we were able to do through the help of an artificial hand expert was to get him a bionic hand that really functions. And second, we were able to work with a financial company to provide, in addition to cash, $5,000 that will be paid to him on a monthly basis for the rest of his life. If you have a personal injury case, or if someone in your family has tragically been killed, call us. We will search for justice for you. I'm attorney Chip Nix, host of Justice for You. Justice for You applies not only to the clients we serve, but also to the community. At nixattorney.com, we provide answers to questions about personal injury with direct access to me and my associates. If you've been injured, contact me at 334-279-7770. Justice for You starts here. We're back with Justice for You. I'm talking with my fellow attorney, Monica Giroux, about premises liability cases. Monica, there's another case that I'd like for us to talk about, if you can help me with this. It's a case where, and actually we've mentioned this case previously in our construction litigation show, but this case also applies to premises liability. It's a case where two people, actually they were brother and sister. They rented an apartment, and they were sleeping one night, and a fire started. The fire started in another apartment. They lived on the second story of the apartment complex, and there were no smoke detectors in the apartment complex. So they didn't know about the fire until the smoke had spread significantly into their apartment. They were asleep. They finally realized there was a fire, but the fire had spread so much already that they could not leave through the front door. They had to go out on the balcony, and they went out onto the balcony and stayed as long as they could, but they ultimately had to jump off the balcony, and they were severely injured, and we helped them with that case. What do you see in that case in terms of the law?
Wow, okay. In an apartment or really in a rental situation like that, it's covered by landlord-tenant law, but you've got the inside of the apartment. And generally, the inside of the apartment is up to the tenant. So, you know, let's change it up a little bit. If they had left a bunch of junk in the floor of the apartment, somebody trips over it and falls, well, that's not the landlord's fault, that's their fault. But
or if they had disconnected a smoke detector
Right.
in the apartment themselves.
we used to do that in college because the popcorn poppers
Oh,
set off the smoke detectors.
Okay.
You got fined for that, by the way. But outside, okay, there's other areas that are called common areas. But in this particular situation that you're talking about, the hazard that actually caused their injury, caused them to be trapped in that apartment, is something that was the landlord's responsibility. It was the landlord's responsibility to have smoke detectors in there that would alert people
Right.
in case there was a fire. So
Absolutely.
those poor people were stuck in a situation where you had to choose between the lesser of two evils.
Absolutely.
And it was either burn in the fire or jump off the balcony.
Right.
So the landlord in that situation certainly violated a duty that they owed to the tenants in that unit or the tenants in the apartment complex in general.
Sure.
By not having working smoke detectors in there to warn them of any potential fire or smoke issues. But
Okay.
that also might fall under, you know, building codes or something you've mentioned before, the life safety code.
Right. The Life Safety Code is not necessarily a law as it was promulgated, but the National Fire Protection Association, they have over 200 different committees, and their sole purpose is safety. And so the National Fire Protection Association developed the Life Safety Code. And the Life Safety Code is totally and solely related to the protection and safety of people who are in structures. I had a case a number of years ago where a young lady, a juvenile, started a fire under a trailer. The trailer burned, 4 people were killed, and yet the trailer company was held liable because they had violated the Life Safety Code with respect to the types of materials that they used. The types of materials used for the construction of the mobile home were very flammable, and they would burn so fast that it didn't give people a chance to get out of the trailer. Additionally, well, it looks like we are out of time. So, ladies and gentlemen, I'm so sorry we didn't get to finish this, but thank you so much, Monica, for joining me tonight.
You're welcome.
And you'll have to come back. We'll have to have you back and discuss this further. But ladies and gentlemen, thank you so much for joining us tonight. We'll see you next time.